A recent Oklahoma City bankruptcy case dealt with a very common problem for secured lenders. The problem arises when a lender extends a secured loan, secured typically by all of the assets of the borrower, but the secured lender fails to file a security interest within 30 days, and there's a bankruptcy. The failure by itself would be meaningless unless the borrower filed for bankruptcy after 30 days, and the lender had still not filed a security interest. I'm not that surprised that this happens quite a bit, because I don't think a lender expects a big borrower to file for bankruptcy within a couple of months of taking out a significant loan. But apparently that happens quite a bit. In this case, what appears to be a private lender called Falcon, and I'm shortening the name, lent over $18 million to a company called Integrity Directional Services. The security interest, that's a big sum, $18 million. The security interest was not perfected until 51 days after the last of the money was advanced. This turned out to be smack in the middle of the 90-day preference period, so it created a problem. The bankruptcy trustee sought to avoid, basically wipe out Falcon's security interest as a preferential transfer, turning Falcon from a secured creditor likely to get paid maybe 100 cents on the dollar if there was full equity, to an unsecured creditor, standing in line with everybody else for a much smaller percent. Falcon conceded that the perfection of the security interest during the preference period satisfied all the elements of 547B, and that among other things, it enabled Falcon to receive a larger share of the estate than if the transfer had not been made. Section 547E2 provides as follows. Unfortunately, while Congress did anticipate some delay in secured creditors perfecting their liens, this provision that Congress provided only gave these creditors a 30-day window to avoid the preferential clawback. If a secured creditor follows security interest in 30 days, she would be protected from clawback. Anything longer than 30 days, and she's out of luck. With $18 million at stake, Falcon did not give up that easily. Instead, Falcon argued that it was protected under 547C1, which protects transfers that the parties intended to be contemporaneous and that are, in fact, contemporaneous, and that's a legal term defined by the court, or defined by statute, interpreted by the court. Whether 547C1 should protect secure creditors that perfect their liens in over 30 days is a huge controversy that resulted in the split of the circuits, the higher level court, the courts of appeals. The 8th, 9th, and 11th Circuit have ruled that 547C2 does not necessarily limit the window to 30 days, and that the court can find that more time is, quote, substantially contemporaneous on a case-by-case basis. Whether 547C1 should protect secured creditors that perfect liens over 30 days is a big controversy that resulted in a split in the circuit courts. The 8th, 9th, and 11th Circuits have ruled that 547C2 does not necessarily limit the window to 30 days, and that the court can find that more time is substantially contemporaneous on a case-by-case basis. On the other hand, the 1st and 2nd Circuits have found that if Congress established a specific window of time in 547C2, then 547C1 should not be used as a loophole to get around the 30-day deadline. This case was in the 10th Circuit that had not yet ruled on the issue, but most district courts and bankruptcy courts in the 10th Circuit have said that a flexible application of substantially contemporaneous should be applied. In its analysis, the bankruptcy court first took a look at Ray v. Security, the seminal case in the 6th Circuit supporting the narrow interpretation. In that case, the circuit court relied on rules of statutory construction, including that, quote, the primary function of the courts in construing legislation is to effectuate the legislative intent, close quote. That court found that the exception for contemporaneous exchange was meant to apply basically to the simultaneous or almost simultaneous exchange of a check or payment for goods, and not for this kind of situation. Also, it found that Congress's purpose in 547C2 was to set a strict time limit to avoid endless litigation by secured creditors regarding the meaning of substantially contemporaneous. Lastly, the court wanted to discourage creditors from waiting until they decided that this borrower was hitting a wall and about to file bankruptcy before filing a security interest. The bankruptcy court agreed with this concept of avoiding litigation and found that while the broader view may protect more secured lenders, it has in fact generated a lot of litigation. So it agreed with the narrow view to that extent. I wonder who benefits from that litigation. The bankruptcy court then cited the Pine Top case, which was the Seventh Circuit Court of Opinion adopting the broad view. Pine Top ruled that it's better to look at these circumstances such as length of delay, reason for delay, nature of the transaction, etc., determining whether there was a reason for the delay and deciding whether the transfer was substantially contemporaneous. Pine Top found that if Congress wanted to limit 547c1 to 30 days or to limit its application to the transfer of goods, Congress would have said so, and it didn't. The Seventh Circuit pointed out that 547c3, which applies to purchase money security transactions, specifically applied a limit of 30 days. No such limit was applied anywhere in the code to non-purchase security transactions. If you don't know the difference between these two, you're going to have to watch more of my videos. Those bankruptcy and district courts following the Seventh Circuit broad view generally look at the explanation for the delay in determining whether the delay was caused by factors out of the control of the bank or the lender. So that's very important in making a decision whether there was substantial contemporaneous. For example, in one case, the bank could not file the security interest since the prior creditor failed to release a prior lien in a timely fashion, and in that case, the bankruptcy court found that a rational reason for a delay. In this case, Falcon blamed the delay on the debtor's failure to have a creditor execute a subordination agreement. While the court was unimpressed with this reason for the delay, it set the whole matter down for trial so it could view all the relevant evidence and give Falcon a full opportunity to be heard. Two pieces of general hypothetical, not legal advice. If you're a secured lender, you need to assume your customer may be 2 months away from filing for bankruptcy and file quickly or have a foolproof explanation on why you delayed. Also, if you're a secured creditor who's constantly in the position of having customers go bankrupt a couple of months after you extend big loans to them, maybe you should consider another line of work.